Welcome and thank you, Bonnie. So I'm Michael Nevins. My friends Alan Lippman and Norman Cantor are on screen, and the three of us, it happens, all were born in New Jersey. Alan and I in Newark, Norman in Trenton, and our professional careers mainly were spent in the Garden State. And now all three of us are retired Altacacos. We live elsewhere, almost. By that I mean now I'm living in New York State. Alan is in Mesa, Arizona. And although Norman still spends half of his every year in Hoboken, the other half he lives in Tel Aviv. And at the start of the war, he hurried back to Israel to show support for family and friends. But this week, he's back here temporarily to attend a family bar mitzvah. And then I think, Norman, you're returning to Israel tomorrow, right?
Correct.
Yeah. So at any rate, in a moment, I'll explain why I started this way, how and why our New Jersey connection relates to today's subject matter. But even before that, I'd like to start much further back, a couple of millennia back, to about the 5th century BCE, when presumably Hippocrates wrote his famous oath. And the Hippocratic Oath has one rarely discussed but crucial phrase, which says that the physician should swear to use his own judgment for the benefit of the patient. Whose judgment? His judgment. Of course, nowadays also her judgment. And scholars have called this relationship between doctor and patient paternalism. The doctor knows best. The patients should merely follow doctor's orders. And when I graduated medical school in the Middle Ages, actually some 60 years ago, that still was the prevailing dynamic. And certainly it was when I entered medical practice in 1968. But it didn't take long before I learned that sometimes those old rules didn't work so well. And the times were changing in many ways, including the doctor-patient relationship. And perhaps the tipping point occurred in New Jersey in 1976 with a landmark decision by the state Supreme Court in the famous case of a young woman by the name of Karen Ann Quinlan. And Karen was in what was called a persistent vegetative state. There was a dispute between what to do between her family and her physicians. Should artificial feeding be continued if it was only indefinitely sustaining a vegetative type of life? And so there was this disagreement. And because Karen clearly could not speak for herself, her father was her representative. And the family had reluctantly decided that prolonging such a life was not in Karen's best interest, but the doctors in charge disagreed. And in effect, the New Jersey Supreme Court's decision back in 76 endorsed an individual's right to privacy in the matter of certain medical decisions. And in certain circumstances, the representative, such as a family member, could speak for them. And incidentally, today we hear echoes of some of the same legal arguments, both pro and con, concerning abortion. Well, back in 1976, physician paternalism was replaced by what was called patient autonomy. What would the patient want and why? And what were the circumstances? And soon the Quinlan decision was followed by many other well-publicized cases, not only in New Jersey, but all over. Many of you will remember the Florida case of Terry Schiavo. There were many other famous cases. And today, we're living in what's been described as the age of autonomy. But as we'll soon hear from our panelists, even that has limits. And so one of our speakers today, Norman Cantor, was a Rutgers law professor at the time of the Quinlan decision, and he served as a consultant for the legal team representing the family. And since I've mentioned him, although he'll be our second speaker this morning, I might as well introduce him first. So Norman grew up in Princeton. He graduated with honors from Princeton University, later from Columbia Law School, taught for some 35 years at Rutgers Law School in several fields, but especially focusing on bioethics. He published scores of articles, including 4 books. And Norman, I can't resist recommending one of them, whose title was After We Die, The Life and Times of the Human Cadaver. Yes, you heard me correctly. And believe it or not, that book is extremely funny. But today, Norman will be discussing legal handling of dying patients, which is distinctly not a laughing matter. But our first speaker this morning will be Dr. Alan Lippman. He's a retired medical oncologist, hematologist, now lives in Mesa, Arizona. For many years, he taught and served on the staffs of several New Jersey hospitals, mostly at his birthplace and mine, Newark Beth Israel Hospital. And he's also taught at what's now called Rutgers New Jersey Medical School, formerly UMDNJ. And Dr. Lippman has a long-standing interest and activity in bioethics. In addition to heading various hospital ethics committees, he served for years on the bioethics committee of the Medical Society of New Jersey. Alan and I also share interests in medical history and medical writing. But as I suggested earlier, New Jersey has had a unique and seminal role in formulating ethical and legal guidelines, and the three of us have all been involved one way or another in that process. And that other states, including New York and most others, kind of followed New Jersey's lead. And I could go on at great length about both of our distinguished panelists, but now it's time to get on with the program. So, Alan, why don't you start things off?
Thank you, Michael, for a very nice introduction. As you said, most of my medical career was in New Jersey, but my wife and I are now living in Arizona, trying to age as gracefully as we can. My talk today will be about navigating what physicians refer to as the dying process, a term that refers to those events that characterize what happens when our lives are coming to an end. Dying is a universally shared experience, yet is uniquely personal. Every one of us will eventually die, but the experience of death and the conditions under which death occurs are different for every person. For the physician caring for patients nearing the end of life, specific ethical challenges characterize the decisions that need to be made at a time when they and their families may be experiencing intense emotional distress. In this talk, I will speak about some of the situations that frequently arise during this fraught time. Decisions regarding resuscitation, mechanical ventilation, artificial nutrition, terminal sedation, withholding or withdrawing treatments, and one of the most controversial issues in contemporary medicine, medical aid in dying. Sometimes I believe inappropriately referred to as physician-assisted suicide for reasons that I will explain. The principal goals of care at the end of life are to prevent or relieve suffering as much as possible and to maintain optimal quality of life while respecting the patient's own desires. This can often be accomplished well with the assistance of hospice care. Ideally, the patient would have an advance directive for health care, a written document that spells out precisely what care a person in this situation wishes to have or not to have, and defines a proxy, a person who makes healthcare decisions if one is incapacitated and unable to do so. A recent innovation, the POST document, also known as a portable medical order, is an advanced care planning tool that tells healthcare personnel, such as emergency medical technicians, what treatments you want or don't want in the event that emergency services may be called. Without POST, EMT personnel are obligated to resuscitate patients and take them immediately to a hospital. A POST document will relieve EMT workers of this obligation and preserve the wishes of a patient who is going through the dying process and does not want this attention. A few words about medical futility. Among the decisions facing patients and families around the end of life are whether or not to implement life-prolonging practices, including CPR, endotracheal intubation, mechanical ventilation, and artificial nutrition. The concept of medical futility refers to a clinical action serving no useful purpose in attaining a specified goal for a given patient. As a medical oncologist, I was often faced with the challenge of whether or not to offer chemotherapy or other relevant interventions, such as radiation therapy or surgical operation, to patients who were deemed not curable, but whose conditions were such that their symptoms could be alleviated and their overall condition could be palliated, perhaps indefinitely. But as a patient's condition deteriorates and further meaningful survival becomes questionable, the likelihood of clinical benefit of further definitive therapy becomes offset by the greater likelihood of harm caused by the typical side effects of such treatment. In this situation, one may make a decision to withhold further definitive treatment. For older individuals who may be terminally ill, such life-saving maneuvers are highly unlikely to afford meaningful benefit or to contribute to maintaining a satisfactory quality of life. Moreover, they're even more likely to cause further harm or discomfort and can be considered medically futile, and thus can be wisely and properly avoided. In these circumstances, one typically considers what is referred to as a DNR order, or do not resuscitate. As an example, take the situation of an individual with progressive and intractable kidney failure. Whereas a younger individual, one who may be in the prime of life, with the potential to survive many more years of a productive existence, would be an appropriate candidate for life-saving procedures such as dialysis or kidney transplantation. Applying this type of aggressive management to a frail elderly individual with numerous comorbid conditions would ordinarily be considered inappropriate, if not inhumane. Doing hemodialysis up to 3 times a week, which would necessitate transportation to a treatment center, perhaps a considerable distance, and require the person's immobilization and physical attachment to a machine for a period of 3 to 5 hours per session, may represent a major commitment, not only by the patient, but also imposes a burden on the family or others needed to support this activity. Moreover, these efforts in themselves would quite likely detract from a quality of life that an individual may otherwise wish to experience. Therefore, patients and their families must be apprised not only of all the benefits, but as well of all the burdens of such interventions, so that they can make a fully informed decision whether or not to embark on such a course of treatment. Given the facts, a rational and satisfying decision can be made. Just because we can do something doesn't mean we should. Withholding or withdrawing treatment. The term withholding treatments is used to mean that life-sustaining treatment is not initiated or increased. For example, in a patient with respiratory failure, a decision may need to be made to intubate the lungs and place the patient on mechanical ventilation, that is, a breathing machine. For an elderly patient, such a maneuver can be fraught with difficulties and complications, and moreover, once mechanical ventilation has been established, it may not be possible to discontinue its use without actually causing the patient's death. The decision to withhold or withdraw interventions is one of the most consternating decisions in end-of-life care. Here, a person's preferences, to the extent known, for example, via an advance directive, must be considered. If the patient's own wishes are unknown or unclear, the physician must know how to manage the discussion with the family in a sensitive and compassionate manner. Terminal sedation. Terminal sedation is a medical intervention used in some patients at the end of life, typically when other efforts to relieve suffering have not succeeded in alleviating discomfort and death appears inevitable. The purpose of terminal sedation is not to cause or accelerate death, but to alleviate intractable and incapacitating symptoms not responsive to other acceptable means. Usually there are 4 criteria used to evaluate a candidate for terminal sedation. Patient has terminal illness, patient has severe and intolerable symptoms, such as pain or breathing difficulties, no longer responsive to treatment. A DNR order is in effect, and death is imminent, measured in hours to days. We come now to a consideration of medical aid in dying. Attitudes regarding aid in dying have in recent years undergone significant evolution, both among the public and within the medical profession as well. At one time, the process was improperly, in my opinion, termed physician-assisted suicide. However, I maintain that this expression does not convey the actual intent of this action. Rather, it should preferably be regarded as a compassionate and humane process representing a form of palliative care in patients who are terminally ill and whose death is inevitable, and who are experiencing intolerable and unremitting existential distress that may consider taking prescribed medication in a controlled fashion to end their lives at a time of their own choosing. Thus, this process should be regarded rather as an example of terminal sedation, a form of what could be termed facilitated natural death, or, as is now customary, medical aid in dying, sometimes abbreviated by the acronym MAID, M-A-I-D. Term I'm not too fond of, but that's what it is. Medical aid in dying was initially legalized in Oregon in 1997 and has since expanded to 10 states plus Washington, D.C., covering about 22% of the United States population. It has been permitted in New Jersey since August 2019. And during this time, nearly 100 New Jerseyans have ended their lives in this fashion. By the way, it is still not available in New York. From an ethical point of view, medical aid in dying represents an expression of personal autonomy in which an individual chooses what they believe to be a humane and compassionate dying experience, occurring at a time when death is inevitable and when they are otherwise experiencing intense existential distress. What constitutes existential distress for an individual may be variable, but typically includes such matters as intractable pain, compromised breathing, or total dependency, representing the need for an intolerable burden of care. What has yet to be shown, but is nevertheless a major area of concern, is whether medical aid in dying represents an equitable and just process available to all. In New Jersey, a demographic analysis of the data thus far shows that about 95% of the people who pursued medical aid in dying were non-Hispanic whites, the majority of whom were college educated. This suggests an inequitable distribution within a population that favors a more advantaged group. In addition, there's a residency requirement stipulating that you must be a resident of New Jersey, thus excluding individuals who reside in other states where MAID is not permitted. There is currently an ongoing lawsuit brought by a resident of Delaware where medical aid in dying remains illegal, who is suing for the opportunity to come to New Jersey for this purpose. This case is pending, but the delay itself can be viewed as troubling. Moreover, because there is no national medical aid in dying law, Medicare will not cover the associated expenses. Neither will Veterans Affairs Insurance, and very few private insurers will cover it. Thus, the process must be paid for out of pocket, and prescriptions for medical aid in dying medications can be extremely expensive, costing thousands of dollars. Another obstacle to medical aid in dying is perhaps the cumbersome process that under the law must be followed, requiring a person to have the wherewithal to navigate the healthcare system in terms of identifying two physicians to attest the individual's qualifications and capacity to undertake the process, following the necessary guidelines and timelines, and locating a pharmacy willing to fill the necessary prescriptions. Among healthcare professionals, there are few today who are comfortable with how to manage patients or others who have expressed a desire to seek aid in dying. To address this need, there's an organization called the American Clinicians Academy on Medical Aid in Dying that publishes a very helpful booklet that can act as a guideline and can provide reassurance that aid in dying can be carried out in a professional, caring, and compassionate way. It is available free of charge, and if I can share my screen, I'll try to pull it up. I don't know if you can see that, but there is a website at which this can be ordered.
If you try to share your screen again, it should work now.
Do you have it?
Scott, can you get the website and just put it in for everybody to see?
I will work on that, yes.
Thank you.
Dr. Lippman, could you share the website in the chat box? I'm having a little difficulty getting the link.
Okay, I'll do that in a few minutes. One strategy that has been shown to be extremely helpful and supportive is the engagement of what has become known as death doulas, or individuals who can serve as advocates and are skilled at assisting individuals and families to navigate the complicated multi-step process to access medical aid in dying. To conclude, it is certain that all of us will die, but the dying experience will be unique for each individual. I maintain that one of the duties of the medical profession is to assure our patients that the decisions we make at the end of life about how the dying process is experienced are just, humane, respected, and compassionate. Thank you.
Thank you, Alan. Norman, you want to jump right in?
Yes, I'm happy to do that. First of all, I want to thank Mike Nevins, first for organizing this series, but also for serving as an inspirational model in how to age well, how to remain active and engaged. I'm sure he's been an inspiration not only for me, but for many others. The topic, aging well, the series topic, is an uplifting one. But our task today is not so uplifting. It's dealing with the sad reality that no matter how brilliant one might perform in the last stage of their lifetime, a final curtain is going to fall. And that's what I see is my task today is to lend some insights on easing that final curtain. Now, for many of us, for many people, that final curtain involves a chronic, degenerative, ultimately fatal disease. Some people, whether because of their religious dictates or because of their powerful will to live, will seek to extend their lives to the maximum extent possible. And I respect that choice, and they're free to make that choice. That's fine. However, my own perspective is significantly different. My own perspective is that the debilitation accompanying a fatal disease process might reach a quality of life that is so personally dismal or degrading that we might want to accelerate the dying process. And that's my focus in this talk, the legal and practical aspects of hastening one's own death. Now, as both Mike and Alan have pointed out, the starting point is autonomy, self-determination in making medical determinations. As Mike pointed out, ever since 1976, the prevailing doctrine has been a right for a competent patient to make their own determination about whether or not to receive medical care, including life-sustaining medical care. And that means that a cancer patient, for example, decides whether and for how long to accept chemotherapy or radiation. Or that means that a competent patient experiencing kidney failure decides whether or not to initiate or continue dialysis. But from my perspective, there's a significant complication that even before the patient's dependence on life-sustaining medical intervention, the dying process might become so debilitating and so distasteful that the patient wants to hasten their own death. That might occur with a variety of degenerative diseases. such as Parkinson's, ALS, MS. Any of them may involve a point of decline that becomes personally distasteful even before becoming dependent on medical intervention. Now, Alan Lippman spoke about one option, what medical assistance in dying, which is, as he points out, a lawful option now in at least 11 jurisdictions in the United States. And as he pointed out, actually, the attitude toward physician assistance in dying has changed dramatically, both in the public eye and in the medical perspective over the last 50 years. It's now a legal option in at least 11 states. However, and he points out, Alan Lippman described the process, and he's right that it's a somewhat cumbersome process and takes some time. But that's not the obstacle that I see as most daunting. I see the most difficult limitation is the fact that in order to qualify for assistance in dying, one has to be terminally ill. And that means that there has to be a medical prognosis of a life expectancy of 6 months or less. And from my perspective, that precludes certain people with protracted degenerative illness who have not yet reached the terminal stage and therefore can't qualify, even if they're in a place like New Jersey or Vermont that leaves that option open. So I want to mention a possibility for hastening death that hasn't been noted so far. It's a lawful option for a patient who's not yet terminal, but who is experiencing a personally intolerable dying process. And that's SCD, the stopping of eating and drinking. The cessation of nutrition and hydration will precipitate one's death within 14 days. The dehydration causes gradually a slippage into a coma within about 5 to 8 days. And the dehydration then precipitates, while the patient is unconscious, cardiac arrest and death within about 14 days. Now, ostensibly, that's a form of suicide because the patient is purposely seeking to die and initiating a process by stopping eating and drinking. Nonetheless, it's lawful because the patient is exercising a self-determination and bodily integrity in resisting forced feeding or artificial nutrition and hydration. And so I think the process is lawful. But there are a couple of noteworthy prerequisites for using stopping eating and drinking. One, the person has to have a pretty firm mental resolve because they're going to have to be resistant to hunger and thirst feelings, at least for a few days. And second, another prerequisite is they're going to have to enlist some assistance for comfort care. The needed kind of comfort care is not particularly complicated. Keeping lips moist, providing medication, including sedation, in case the patient becomes agitated or delirious before slipping into unconsciousness. Now, stopping eating and drinking is not ideal. It involves a period up to 14 days. It's a lingering process as opposed to the expeditious process of taking a poison, as is the case with physician-assisted dying. And also, it involves a unhappy death watch, or what might be an unhappy death watch, for those people who are around, loved ones or caretakers. However, you, the patient, control who you notify that you're doing this process, and you control who's present. So I think this is an option, a legal option for hastening death, and deserves consideration. It's not ideal. It's somewhat cumbersome, but it's not an anguishing process, and at least anecdotally has been a successful way for many patients to end their lives. Okay. Up until this point, have I already talked 20 minutes? Wow. I'll try and meet what I promised, which was no more than 30. I want to shift gears. Up to this point, I've focused on competent patients, people who are capable of understanding the variables in medical decision making and making their own decisions. I want to speak as well to the fate of the now incompetent patient. And if, like me, and the incompetence can occur as a result of a variety of circumstances. Sometimes it's a result of sudden trauma, like a stroke or a brain injury. Other times it's the result of a gradual process, such as dementia, such as Alzheimer's. If you don't leave instructions, someone and a life-sustaining medical intervention decision becomes apparent, someone's going to make that decision for you, usually the next of kin. But if you care, and then that might work out, but there are a lot of variables about who that last decision maker might be, and who the physician and what the physician's personal dispositions are. So if you care about lingering in a gravely debilitated status, as I do, it's far better to take some advanced steps to shape your post-competence fate. And again, the law gives a measure of autonomy, what's called prospective autonomy, some self-determination in shaping your post-competence fate. The most important element is naming a healthcare agent, someone you trust to make any critical medical decisions after you've lost your own competence. But the perhaps even more important element is issuing instructions to the healthcare proxy that you've chosen. And it's useful and important to state the degree of debilitation which you consider so distasteful that you would prefer to be allowed to die. If we talk about dementia, for example, a common formula that a declarant this issuing instructions uses is, if I no longer recognize my loved ones, I don't want life-sustaining intervention. My formula is more drastic. In my advanced directives say, I no longer want life-sustaining medical intervention if, quote, I can no longer read or understand written material such as a newspaper. Now, that's a pretty radical position, but I witnessed the demise over a 10-year period of a person who's very beloved to me. And I understand what it's like to be mired in extreme disability, cognitive dysfunction, and dependence. And I'm determined to avoid that status. And therefore, I've issued my advanced directive based on not being able to read or understand. And notice, it's not based on distress or suffering that I expect to experience as a demented patient. It's based on my assessment of a level of intolerable indignity, a level of decline at which I don't want to be remembered by my survivors. And in addition, I don't want to be a prolonged burden on caretakers. I don't want to be either a physical, psychological, or financial burden on my survivors, even if they would gladly perform those tasks. And therefore, I've used the formula, I no longer am able to read or understand written material as the key criterion. Now, one important caveat. You'll notice that it doesn't involve distress or suffering in any way. And what that means is I may be content as a gravely demented patient, not suffering. And that in turn challenges both the agent who's I've named and any physicians who are cooperating in honoring an advanced directive. And so in my advanced directive, I explicitly note that my choices are not based on suffering. I understand that I might be content as a gravely demented patient. Nonetheless, I don't want medical intervention. Well, I've tried to present my own perspective here on easing the final curtain, and even, at least for me, that might involve hastening death in certain circumstances. And I will stop there and give my colleagues and an audience a chance to ask their questions. Thank you.
Thank you, Norman. You know, I suspect everybody will have their own responses, on one level sympathetic, on another, various concerns. We could probably spend hours debating this, and we probably have about 10 minutes. But I would like to, rather than us getting involved in a discussion between the three of us, I might say that I'm going to ask Maya when she comes back on to post something that I wrote a year ago, which talks about all of these issues. If you're interested in reading that. But at this point, I'd like to open up the floor, and my guess is that Norman's rather idiosyncratic position may elicit a little bit of discussion. So why don't we see some hands? If I can't see hands of people whose names are on the screen, but I don't know who's monitoring this. Scott, are you there?
I am here. I'm looking now. I don't see any hands raised in the participants. I can't see if anyone has screens off with their hands raised. But we did have a question earlier for Dr. Lippman.
Good.
Roy Levitt asked, in terminal sedation, does the patient have to be in a condition to physically participate in the application of terminal medication?
The answer is no. Person does not have to be cognizant of what is going on, but the sedation can be administered without causing any additional distress.
Tony Diamond has a question. Go ahead, Tony.
So I'd like to address my question to Norman. First of all, Norman, I'm a fellow Trentonian, so just for chuckles. Listening to your guidelines that you've put into your advanced directive, where upon any of that can the state or any government agency challenge your directive? Are there very specific guidelines that you cross a line where a government agency could intervene on your directive?
The only I think the short answer is no, but in other words, I think that the principle of prospective autonomy allows me to, in advance, make the same kinds of decisions that I could have made if I were competent. And that's a vast array of decisions. The most problematic element is hand feeding. In my advanced directive, indicate that if I have no more interest in eating as a gravely demented patient, I don't want to be fed. That is the most problematic element, because certainly some people in the medical profession deem nutrition as not part of medical care. Hand feeding is simply basic care. The other limitation, I think, is the notion is not because I don't have a legal right, but because people are troubled by assisting in the death of someone who is not suffering and seems content, is not complaining, and if is not asking to die. It's difficult to end the existence of a person, although significantly mentally debilitated, or get some kind of rudimentary pleasure out of listening to music or watching television. I don't want to be sustained at that point, but some physicians will be reluctant to cooperate because I am still content. I tried to be responsive to your question. I don't think there is a legal obstacle so much as practical obstacles of getting the cooperation of your agent and of the medical personnel who are around.
I'd like to ask a question directed at both of you. Alan, you had both of you had mentioned that there are now 11 jurisdictions that approve of the acronym MAID, this medical assistance in dying. But New York State, I know that notion has been introduced in the legislature, but it hasn't gone anywhere. And I'm wondering whether you have any specific details about why, what's held up that in New York State. Is it a question of the slippery slope argument, or is something else accounting for that?
I think this is
Alan,
a problem in every state that has considered the legislation. I know in New Jersey, it was 6 or 7 years that the resolution, or actually the law, the statute had to be reintroduced into the assembly and discussed and debated. And it was not until the 7th or 8th year that it was finally accepted. Similar experience occurred. I don't know how long it took in Oregon, but I know in California, after several years, they did pass the resolution. And then it was held up in the courts. Maybe Norman can comment on that. So it's a gradual process, and it takes a long time to institute these laws.
I don't know I answered Mike's question about New York, but I know historically that the Roman Catholic Church has exercised a lot of influence in New York State. And so my guess is that that is one of the significant barriers to getting the legislation adopted in New York.
Scott, are there other questions out there?
Not in the chat, but I actually had a question for the panelists. I was curious that even in those states where you have allowance medical clearance and legal clearance for these procedures, if any of the states have enacted additional steps or policies that have to be gone through first that serve as any kind of roadblock or delay on the overall process.
No, the process is slightly different perhaps in each of the states, but the overall intent is the same. And but as Norman mentioned, it's a cumbersome process, and not many people can do it in a comfortable and effective way.
There are moves to facilitate the process. In Canada, among other places, the process is less cumbersome than in the 11 states. And the protections that were in place were to prevent the slippery slope of allowing of having involuntary assistance in dying or euthanasia. But I think that the process is too cumbersome today, and I think there are movements in states to make it more facilitated.
Do you think that the fact the intense political and philosophical arguments about the beginning of life, which is so contentious, would impact upon the discussions about the end of life? And do you think that some of the advances of the 1970s and 80s, decisions by the courts, if they were being decided today, whether they would be as likely to have been passed in terms of brain death criteria, and even the legality of advanced directives. I think things have changed drastically, and I don't know that those landmark decisions would pass as easily today as they did back in the 70s and 80s.
Cultural attitudes change over time, and they can become reactionary. Look what's happened with the abortion situation. Roe versus Wade was in effect for almost 40 years, and now it's been turned around again. And I'm sure it'll come back another way sometime in the future.
Roy Levitt, you had your hand up. I think you're muted.
Unmute, yeah. I just wanted to expand a little bit on my question. I have a son who's an emergency room physician, and he's taken a few courses on end of life, issues in various states that have these laws in place. And one of the things he told me was that the decision and directive needs to be made at a point when the patient is still able to physically use a hand to either inject a solution necessary for the end result, or to disconnect a pacemaker or an electronic instrument, something like that. The patient has to be a participatory part of the process. And that's why I asked that question.
Yes, I think that's correct. And there's a recent article by Tim Pope, other authors, who argue that that is an inappropriate limitation, that there are disabled persons who can't themselves engineer that last step, and that they ought to be able to utilize the option just as other people can.
I would add, it depends on the jurisdiction. Canadian law is much more liberal than American law, United States law. In fact, it allows euthanasia. Euthanasia is prohibited in every jurisdiction in the United States, so that it varies by jurisdiction.
Not only jurisdiction, but national the differences in the Netherlands and Belgium and Switzerland, where they have legalized in certain situations active euthanasia, and it does not seem that they have descended into terrible immoral state. And in fact, they have gradually been liberalizing their criteria over time. So it's not that just on this side of the Atlantic, this is a unique problem. Others have dealt with it, and seemingly successfully. Some Americans, in fact, with terminal illnesses of various types, have actually made the trip across the ocean to avail themselves, even though that's costly and complicated.
I think the experience with assistance in dying universally has refuted the alarms that had been sounded about abuse. I don't think there's virtually no documented abuse, even though assistance in dying is pretty widespread.
I might make one other comment. Norman's suggestion about what did you call it? SED, self cessation of eating and drinking, may have been shocking to some, But I might point out that back in 1985 in New Jersey, the Supreme Court heard the case of a woman with advanced severe dementia who had was being sustained on a feeding tube. Her name was Claire Conroy. And that was another landmark decision, the first in the United States, that permitted artificial feeding in this context to be removed. And those who opposed it, before the Supreme Court, used rhetoric like cracked, bleeding lips, sunken eyes, convulsions, all sorts of terrible adjectives, which in turn was rebutted by nurses and physicians who, in fact, did care for terminally ill patients. That is absolutely not the case. And although it may sound to those listening to me now that would be a horrible way to go, in fact, that is not the experience in practically all cases. And although Norman points out that the average length of duration of life absent fluids or food is about 14 days, sometimes a little more, sometimes a little less. Usually after a couple of days, the patient seems comfortable. And as long as he mentioned the lips are moistened and so forth. So, it's a very emotional subject. But I think that even though it may be that the majority of people wouldn't go as far as Norman would like to go in his case, it's provocative, and these are types of discussions that are not held until there's an emergency, and the chances are that there should be a lot more public discussion about them. If there are no other hands up or questions, I think we can call it a day. And I really want to thank Norman and wish him well when he returns to Tel Aviv tomorrow, I think, Norman. And Alan in the heat of the Arizona desert. And wish you all well, and hope that some of you will tune in next week for the final of this 4-part Zoom series. And I think Scott wants to close us out. Do you have a comment?
Well, I just want to thank everyone for the fantastic conversation. I do also wanted to mention that the booklet that Dr. Lippman mentioned, a guide for patients and their supporters, which is obtainable PDF online. I have posted the link to that in the chat box. So if anyone would like to review it, they can make reference to the link. I want to also, as Michael was saying, I hope everyone can join us next Wednesday at 11, where Rabbi Paula Drill will close out the program with a fantastic talk analyzing Jewish texts and values that lead us to an uplifting perspective.